The Scale of Justice, that program on the network service of the Nigerian Television Authority that gives you an insight into the happenings in the justice sector of our polity. I am Femi Okewo with the pleasure of having you on today's edition. It is an area of concern in our justice system, but which not many people pay attention to. It is the juvenile justice system in Nigeria. There doesn't seem to be any serious attention being paid to it, because just visit any of our correctional centers and you'll see the number of underaged people and children that are wallowing along with convicted prisoners. And that is not good for our social system in Nigeria, where young people or juveniles who are found on the wrong side of the law are harbored along with the hardened criminals. Of course, there's very little chance of them being truly corrected. And so the federal government is of recent been paying attention to it, and of course through the Presidential Committee on the Reform of our Correctional Centers. You remember some time ago, this committee paid a visit to the Correctional Center in Lagos and also tried to visit the one in Ogun. But then the Attorney General of the Federation now sees it as also an area to look at. Recently, the Attorney General of the Federation addressed a virtual meeting of Juvenile Correctional Center personnel, and that is what we're going to start with before we go into the history of what has been done in the last few months about juvenile system in our correctional centers. This is another phase of the assignment of the Presidential Committee on Correctional Centers Reforms and Decongestion. With only 3 federal government-owned juvenile remand homes in Nigeria, efforts are now being made to see how a partnership can be generated for states to run centers similar to what Lagos State is doing. At this meeting, with the Ogun State juvenile justice sector joining virtually, the Minister of Justice stressed the need for greater attention to juvenile justice in Nigeria.
The Federal Minister of Justice, in collaboration with the Presidential Committee on Correctional Service Reform and Decongestion, under the directive of Mr. President Muhammadu Buhari, flagged off the 2020 presidential pardon and clemency granted in April 2020 to convicts in correctional custodial centers across the country. This was done as part of the measures to decongest the custodial centers nationwide in the wake of the COVID-19 pandemic. The Federal Ministry of Justice, in collaboration with the Committee and the United Nations Children's Fund, UNICEF, commenced the first phase of the Juvenile Decongestion Program on the 29th day of September 2020 with a virtual interactive session of the Honorable Attorney General of the Federation and the Honorable Attorneys General, heads of courts, and commissioners of women affairs of all the 36 states of the Federation, in order to target the necessary needs and requirements of the juveniles to be released. The ministry dispatched a team of 4 experts to the Federal Postal Institute of Adigbe, Abeokuta, Ogun State, to conduct a profile, need and risk assessment of the juveniles. The assessment exercise took place from 20th to 21st day of May 2021. To this end, today's meeting is aimed at organizing a coordinated judicial action to provide legal and psychological support to released juveniles for proper integration back into the society.
Chairman of the Presidential Committee on Correctional Centers Reforms, Justice Ishaq Bello, and the Chief Judge of Ogun State spoke on the collaboration between states and the federal government in this regard.
This occasion is of huge significance to me because I see it as an opportunity to yet strengthen the capacity of the Nigerian Correctional Service towards good service delivery as it concerns juveniles in the detention centers. One of the major objectives of the correctional reforms and the ensuing advocacy campaign of the committee is to reposition the Nigerian Correctional Service centers as well as bolster the institutions, remand homes with the mandate to rehabilitate and reintegrate inmates, most especially juveniles, back into the society. For any released child, the committee will continue to work with the Ministry of Women Affairs of Ogun State to ensure proper integration and rehabilitation.
The courts normally commit to the foster home or juvenile institutions children in conflict with the law and above parental control for reorientation, reformation, and final reintegration into the society. Most of the times, the courts commit to custody for a certain period of time. However, no one is ever sure of the time and process of reintegration at the foster home. Unlike the correctional facilities for adults, where they are released when their terms are concluded, it is unsure what the process for reintegration and reconnection with their prospective families for the child offenders are. After the conclusion of their terms. In fact, some end up staying at the foster institution for long, even after their term is concluded. In an effort to counter the deviant behaviors perpetrated by certain youths in the society, the government, through Section 4 of the Foster Institutions and Remand Centers Act, Laws of the Federation 2004, provides that, I quote, "The object of foster training shall be to bring to bear every good influence which may establish in the inmates the will to lead a good and useful life on release, and fit them to do so by the fullest possible development of their character, capacity, and sense of personal responsibility."
About a year ago, we wanted jointly to start an initiative with regard to the enhancement of rehabilitation and reintegration capacities at Maiduguri Maximum Security Prison, where a large number of suspected associates of Boko Haram are being held. And we are glad to be able to announce that this project in the meanwhile has actually commenced. And there is a mission presently actually looking at the upgrades of the recreational, vocational, and educational facilities at that prison. And we hope to be able to expand that project into 2022, 2023, provided we get additional funding.
As part of COVID-19 mitigation strategy, I'm very pleased to say the joint advocacy that was done between UNICEF and UNODC to influence the government of Nigeria to implement the recommendations of the technical notes for children deprived of their liberty was very, very successful. This led to the release of a total of 689 children. That was in just last year. And then if you look in terms of the totals we now have, we are well over 700, which is a remarkable achievement that has been done by the committee. So short efforts are laudable, and UNICEF, as well as our sister agency, UNODC, we applaud the efforts of the ministry and the tireless commitment under the dynamic leadership of the Presidential Committee.
More states are to be explored for an improved juvenile justice system in due course. That was the Attorney General of the Federation that addressed a virtual meeting which tried to look at the juvenile juvenile justice system in Nigeria. And we used that as a footing to look at what the Lagos experience is. You remember the Presidential Committee on Correctional Centers and Reform visited the Lagos centers to see how states can help in complementing what the little the federal government is doing. Of course, you remember we also told you that there are just about 3 juvenile centers across the country that is most inadequate. So if states like Lagos has done can come in, I think it will help. So let's take a brief look at what the Lagos experience is. The Nigerian criminal justice system does not allow juveniles to be incarcerated or remanded in correctional centers along with adults. But the experience of the Presidential Committee on the Reform of Correctional Centers in the last 3 years of its existence shows that this rule has always been violated, with children found in various correctional centers across the country. This is why, on resumption of its tour of correctional centers, focus is now on juveniles and efforts to reform them.
Well, actually, we're here not to make any releases of anybody. It's not within our competence to do that. We're here essentially for the purpose of seeing the excellent work the state has done, because we show once we're able to make this situational assessment, we'll be able to make our report.
Thank you, sir.
It's a pleasure.
There's a school within the premises. That is going to happen.
Okay.
We have those that go to secondary school outside, depending on their cases. Because of course, the criminal child will not license to do with criminal aspect. Except it's not even possible for us to allow to go outside the premises. And others that we do allow to go outside the premises, we have to make application before the courts. Yeah. For them to be aware that this girl is go outside.
Because it's just the court that ordered the remand.
And those that we know that have this abscondment history, because they don't want them to go outside once they have your parental control. Because we don't want to speak up where they will abscond from school. And hence it's going to be a lot of problems in the ministry.
How do you reach out to parents whose children disappeared but found with sufficient address of contact of their parents? How do you go about that?
The first thing is that usually when a child comes into the home, you can have the word. It's a word that can talk or can write. You give the child a paper to write about himself. So based on that, again, if the child knows where she is coming from, fine. And if doesn't know where she comes from, you know the next thing to do. So usually when the child is placed in the home, we have what they call care plan. And that is care plan. The care plan has to do with, it's like immediately the child comes into the home, you start working on how the child is going to be raised. So the care plan is, we interact with the child, we ensure that it's friendly environment. If not, the child needs to be like, most of that always fall inside with that, they tell you everything about yourself. Can we take them a while first day? So that then aside from that again, we have things that we do here. We have pregnancy kits that we have to test them to if the child is pregnant or not, because they have been found on the streets. So anything must have happened.
You cannot allow them to be on the street and just give them all this thing and bring them here. Even their parents, they know sometimes that they are here and here. They come for visiting like that.
Because we also, like I said, we investigate the parents too. Some of them are not like, most of them, their parents, they are having like 7, 8 children. And if one is out of that, they are even happy that So sometimes they come here and they see the serenity of the environment and all that. They say, okay, this one is even better than my home. Better still, they still call them to beg them to come out. But sometimes you don't compel them. Because if you force them to have them, they go back to the system. Like what we done.
With the kind of facilities found in the two centers, Justice Ishaq Bello said that they can serve as model for other states in the country. Of particular interest to the Presidential Committee are the academic and vocational education being given to the inmates. This, the committee says, should also be replicated even at the federal level, which has only 3 juvenile centers across the country, one in Kaduna, Ilorin, and Abeokuta.
The issue of remand homes is a very old history. State governments ever since have found a way or the other to put in place remand homes within their respective states. I don't know whether it is part of the clamor to have their own prisons, which was the case in the regional days. But all I can say here is that I have come to the Lagos State, and it is by design from the committee, because we want to come and see what facilities are here, how do they run the structures, what is the means by which, what are the means by which they finance the institution and the personnel who takes responsibility for their salaries and what have you. Now we have selected about 4 states. The reason being we want to enhance juvenile justice across the country, and we believe part of our report should be very comprehensive enough when we submit our recommendations to Mr. President as to what's to be done to address child crime. All right? Now, Lagos is one of the states that we have not pinned down to visit. And I can say so far it is an excellent experience. For them to think of having a particular segment or a unit within the structure of the correctional unit to go around for the purpose of picking abandoned children, all right, regardless of which corner of the country that child happens to come. And some of them never saw any classroom. Today, the history is that quite a number of such children brought in had gone through here. Some of them are practicing quite a number of professions as graduates.
Juvenile justice is a major component of Nigeria's justice dispensation system. So far, the experience has been that states have always used the excuse that the prison system in Nigeria is under the exclusive legislative list of the Constitution. And so that gives them an excuse not to do anything about juveniles that are found on the wrong side of the law in their states. But the Lagos experience has shown that states can do a lot to intervene in the justice system, particularly the juvenile arm of it in Nigeria. Before we go, let's take a run through our courts across the country on the segment for
A federal high court sitting in Abuja has said that the former finance minister Kemi Adeosun did not need National Youth Service Scheme to take up any ministerial appointment or be forced standing for any elective office in the country. The court held that Adeosun, who graduated in the London University in 1989, was already 36 years of age before exemption from the participation in the NYSC scheme. Delivering the judgment in a suit, Justice Taiwo held that Adeosun, from available facts, was a United Kingdom citizen, having been born in UK in 1967 and remained there till 2003 when she came back to Nigeria. That Adeosun became a Nigerian citizen by virtue of the 1999 Constitution, which came into force on May 29 of the year. Therefore, NYSC Act will not have effect on her. The judge said Adeosun would have committed a grave crime against Nigeria if she had participated in the NYSC, having attained the exemption age of 36 years. 8 suspects in the alleged rape and murder of 24-year-old University of Ilorin student Olajide Blessing were finally arraigned in court. The court has declined their bail application. The arraignment of the accused persons could not commence last Wednesday because of the inability of the 3 of the suspects to produce legal representation. The defendants were brought before the court by Kwara State government on 11-count charge of armed robbery, illegal possession of firearms, rape, among others. The suspects were all in court under heavy security mounted by the DSS. They all pleaded not guilty of the charges. The lead prosecution counsel, Attorney General for Justice in Kwara State, filed an application to call 3 more witnesses. The 7th accused person, aiding and abetting and receiving property products of armed robbery, also filed an application for bail. In dismissing the bail application, the 7th accused person, the court said counsel to the defendants did not give satisfactory condition for ascending to his requests. The trial judge was angered by comments Solaburu made in an interview he granted journalists after Tuesday's sitting following the rejection of his bail application for his client, describing the comment as a sign of indiscipline. Justice Ibrahim Yusuf of Kwara State High Court in Ilorin on Wednesday ordered the arrest of one of the defense counsel's, Barrister Sikiru Solaburu, in a case of alleged rape and murder of a 300 female student of University of Ilorin, Olajide Omowomi Blessing. At the resumed hearing of the case on Wednesday, the trial judge issued a bench warrant for Solaburu. Defense counsel for 7th defendant Dawood Bashir Adebayo, charged with aid and abetting and receiving stolen items through his secretary, Barrister Solaburu, had served the court his intention to withdraw from the case.
That's the much we have for you this week. Of course, there would always be unfolding justice-related matters, and you have nowhere else to look for them except on the scale. We'll see you again, and thank you for being part of today's edition.